All right, so today we'll discuss the second question of November 2024 general papers. Okay, so this is a thought question, as we all know. And okay, I'm not going to read the question all over again. What I'll do is, okay, we'll straight go to the question. Still a lot of people joining. Okay, first, you are being invited to discuss the possible course of action and to identify who is the defendant and what other defense available as to absolve their liability. Okay, so this is your task here. Okay, so normally, regardless whether this is a contract question or a tort question, you will need to identify the parties first. Okay, here what is the special is that the name given in the question itself is just Mrs. Allen, correct? But it is not the full name of the plaintiff, the first plaintiff in the question. So you really need to read the police report, which have mentioned the name of the plaintiff. This is very important because you are going to lose mark if you just mention Mrs. Allen in the statement of claim. And second thing is that the question emphasized that, you see, Chin Mei here. Chin Mei is supposed to be the second plaintiff, and she's just a minor, less than 18 years old. Anyone who appears to be a minor, he or she cannot sue in personal capacity. She has to sue through the legal representative, okay? Next friend or kin, something like that. Wakil litigasi. And the action here, obviously, is negligence. It involves a dog bite incident around the neighborhood, isn't it? Okay. And the only realistic defendant here in this case are very clear is Mrs. This Madam Wong. Okay, this Madam Wong appear to be the owner of Rottweiler here. Okay, so this is a dog. So you bring this out first, and then subsequently you elaborate on this course of action. So how to elaborate your course of action for negligence is that first you must identify the relationship of the parties so that you can impose a fair and just duty of care to this person, to this defendant, Madam Wong, in the question. Okay. And secondly, you have to prove the defendant has breached, okay, the duty of care. How do we know when a person had breached the duty of care is that when he or she perform below the standard of care that is ought to be done. So this is how the breach occur when she fell short of the standard of care. And subsequently, the third element will be causation. Okay. Causation is highly linked to the fourth element, that is the damage, kerosakan yang dialami oleh plaintiff. Okay. Reason being is that you must prove the damage is caused by the actions of the defendant or breach of duty lead to the directly lead to the damage suffered. Okay, and the said damage must not be too remote. So this is basically the four elements that you need to prove in the question. Okay, and in terms of duty of care, the most applicable principle will be neighborhood principle, okay, in Donahue and Stevenson. This case here means that if, let's say, for example, a defendant does something or avoid doing something, his action is so closely and affected one individual. So in this case, the defendant will automatically be deemed to owe a duty of care to that particular individual. Okay, so this is very simple. As long as, in a very layman term, as long as you are near to me, whatever I do or I don't do will have direct impact on yourself, then this duty of care is owed. Okay, but you cannot just argue the legal principle just like that. Okay, you have to argue further. Okay, so how does the question here, for example, involving a dog, will play a role? Okay, first thing first, you must know that this is actually, is there any, first thing first, you must say the Donahue against Stevenson as a general principle. As far as the second step is concerned, the approach is that, is there any similar case sharing the similar facts that you can draw analogy to persuade the court to impose this standard of this duty of care. You get me, so far? That means to say, first, you argue they are so close to each other because they are neighbor. Second, you need to convince the judge, say that, look, previously there is an animal ownership issue whereby in this particular case, Priyasamy against Supia, the defendant bull suddenly lost control and attacked the plaintiff and caused injury. So actually the court found that the defendant is liable. So there is some analogy you can draw from old case. That means to say the court has set a precedent, such relationship exists, easier for you. Okay? And for you to distinguish when do you apply Donahue and Stevenson, or this Caparo Industries again Dickman will be, or this in Malaysia, a firm in Tenaga Nasional Berhad against Batu Kemas would be, is this situation a repeated or an old situation, or rather we have a lot of supportive case law that already form out. This should be the way. I give you one classic example. Doctor-patient relationship. You do not need to argue this is a new form of relationship that should be imposed. So you no need to say, except you say Donahue and Stevenson, you don't have to tell, because this relationship itself is not a new form. Okay, let's say, for example, recently we have some case, teacher and student. If the teacher is lazy coming to class, causing the students fail their SPM, the question put forward to the court will be, did the teacher really owe the duty of care to the student? You get me? So this is never been decided elsewhere in Malaysia before. Take for example, the court will look at the proximity issue, the forcibility issue, as well as the policy in Malaysia to impose such duty of care to the said teacher. Now you understand how to use this different legal principle. Don't simply just gossip only, Okay. Next, because Madam Wong keeps this is quite important lah. This is quite important. Okay, because Madam Wong kept a large Rottweiler dog in this particular neighborhood. So that means to say she really owe a duty of care to whoever that pass by this hiking path. Okay, because there is a chance the dog will escape and harm the person. So you must be deemed to owe a reasonable form of duty of care to those neighbors. Okay, so this is how you relate the facts into the question. Don't just talk about Donald Stevenson, habis. You are just citing the law. The examiners want you to apply the law. Okay, we go to second element. It's quite easy. Breach of duty. So breach of duty because Madam Wong is just an ordinary folk, isn't it? So the standard is just reasonable dog owner in the circumstance. Okay, only professional, for example, lawyer, doctor, architect, accountant, those with annual practicing certificate, Bolam test is applied. You get me, so far? Bolam means you have to compare with the opinions of the peer. For example, a doctor with a doctor's opinion to say that this doctor is breaching the standard of care. Okay. So you need expert opinion in this sort of case. Whereas if reasonable dog owner in this question in particular, you do not need to call some high-fi person to come to court. You just have to establish as a general benchmark, say that if I am the reasonable dog owner, this is what I should do at my own house. For example, tie the dog, okay, keep the dog inside the cage, or even provide some training to the dog so that it doesn't bite anyone. So this is how it goes. Okay. But somehow or other, you cannot stop the discussion of breach of duty just like that. You have to associate with the relevant facts here. The most critical facts that you have here is inadequate fencing, isn't it? Because the text clearly tells you, the case clearly tells you the gate itself is just 4 feet high, isn't it? But whereas if a large Rottweiler it stands up, it could reach 6 to 7 feet. So that means to say either the dog can jump across the gate or can easily push the gate open with its force. So this is how Madam Wong in practice by virtue of this question, fell short of her standard of care. So this is number one. And by the inference, you see the drafting that I use, factual evidence or inference. Second thing is that certainly the dog was not tied and not kept. Otherwise, it would not kept free, isn't it? So you can make out such inference. And the third one is keeping an aggressive species of dog because Rottweiler are quite known for aggressive, for being an aggressive breed. Okay. And fourth, failure to give proper training to the dog and failure to put a muzzle, that means to say something like a dog punya mouth, they put a lock so to prevent the dog from biting a human. Okay, and some more they do not actually provide sufficient warning to anyone that pass by the area. Beware of a dangerous dog, something like that. This one also very important. Otherwise, the passerbys, the pedestrian, they will get alert and try to avoid this area. Correct or not? Okay, and leaving the dog unattended. And the eighth one only I put unlicensed. Why I say unlicensed is not so much. Neither is that if you tally the whole situation all together, you tie up the whole story. An unlicensed dog does not bring any bearing to the negligence itself. It simply means that the dog does not have a registered tag, isn't it? You saw, isn't it? Sometimes the dog will keep a tag issued by Majlis Perbandaran one. That means the dog is licensed and owned by somebody. But it does not really mean the dog owner automatically negligence because there's no registration, no proper licensing. But somehow or other, you can try to circumvent the facts a bit. You can say signifies lax control on part of the owner just to bring her down lah, isn't it? Said that she never care lah. You see, even the dog is not properly licensed. So this is how you frame your answer. And there's one criminal conviction you can do a little bit of discussion because I think question B asks you to discuss, isn't it? So this criminal conviction is somehow persuasive, okay? Persuasive, to what we call to the court that she breached the duty and negligence, okay? And this is your summary. Okay, and causation and remoteness. Causation, we have two types. The first one is the factual causation. Normally, we use but for test. In this question, but for Madam Wong's failure to secure and restrain the Rottweiler, the dog would not have escaped through 4 feet gate on this particular date and not attack Alam Yap and Chime. Okay, so this is the whole but for. If it is not because of your fault, this whole thing will not happen. And the causal sequence, you can elaborate is that because you breach, you don't lock, you don't restrain, the dog escape, subsequently attack, and cause injury. After the injury, the plaintiff suffer loss. Okay. And in terms of factual causation, there is no factual cause intervenes. That means to say the chain itself is intact. There is no what we call novus actus intervenens. Because if you read the question, I'm sure you have known that there is a delay in the Seremban hospital part. So does this delay itself a separate new thing, new act that actually caused the damage to be worse. Okay, but somehow or other I say it's not lah. It's not lah. Otherwise, you have to bring the Seremban General Hospital in the suit. Okay, so this is not lah. And another part is that you can use also material contribution because sometimes but for is a straightforward thing, But for, okay, but for the defendant action, the plaintiff will not suffer from loss. But the facts here somehow rather suggest that there is a little bit disturbance from Seremban General Hospital. So the question here, is it really a but for or material contribution test will entails? So if you are not so sure, you submit both. Okay, you submit both. Okay, material contribution means that most of the damage suffered by you, okay, then you habis. Okay, so this is material contribution. And legal causation has a lot to do with the damages, the damage part. We also need to look at the Weger-Moll test. Okay, so you have to, in summary, you have to relate to the facts. Okay, that means to say a large, powerful dog escaped and then bite the pedestrian. Okay, and you said there is no novus actus intervenus. Okay, subsequently, you look at the damage. The damage, I think you can save your time by saying that you will answer in detail in question 2C. Okay, no need to write so much because you're just wasting time and repeating yourself. Okay, the third part of the question, first you are asked to identify who is the defendant, isn't it? Second, cause of action. And third, you are asked to put out the defense for Madam Wong. Okay, so how do Madam Wong wanted to win the case rather than the plaintiff should win? Okay, The likely defense here, I will just say lah, I will just say, okay, contributory negligence pursuant to Section 12 Civil Law Act, in which to say Mrs. Alam's own lack of care may contribute to the injury. How she is lack of care? The factual allegations that could made by Madam Wong derived from this question will be first, that is to carry a stick. The carrying stick thing could have provoked the dog and result to that attack. Without the stick, without that means there is no attack at all. So this is how Alam, the plaintiff, may have contributed to the incident. So this is how okay. And failure to retreat. Okay, for example, if she had seen suddenly a big dog jumping out from from the gate and then start moving quickly towards her direction, she should have run, isn't it? Okay, so this is failure to retreat. Okay, and if let's say the situation show that she had no lash about that the what we call the Madam Wong kept the dog and the dog is a fierce species, she would have avoided that route. But nevertheless, I think those arguments are a weak one, a weak one. Because having said so, the stick itself is for what? To deter monkeys, isn't it? It is not meant to hit the dog, or provoke the dog. It's just to protect this Alam Yap and also her own daughter from being harassed by these monkeys. So based on the fact, I don't think it is likely. I don't think it's likely. Okay, but somehow or other you can also say that contributory negligence is partial defense lah. Okay, it does not absolve Madam Wong's liability as a whole. Take for example, if let's say for example, you win a case, normally you get 100% apportionment of the damage. Okay, 100% kerugian yang kamu alami, kamu punya, kamu menang. But let's say contributory negligence means the court will say 70% you have to give to plaintiff, but 30% because of your own contributory negligence, you are not entitled to take. You get deduction. Okay, so this is the purpose to plead contributory negligence. Voluntary assumption, voluntary, just like I said, you appreciate. Uh, I mean, the plaintiff appreciate, but I think this is also a very weak defense, very weak. I think the defense is unattainable. Okay, and inevitable accident. This one I think also very, very difficult because this whole dog's escape thing, you cannot say that I can't I exhausted every single remedy to stop it. It is from God lah, cannot. So quite weak defense. Okay. Hospital negligence, like we have discussed, but I don't think so. I don't think so. It's just some mere delay. It does not lead to new complication. Let me tell you one thing. If let's say the dog bite has caused severe bleeding over the limb of this Mrs. Ellen, subsequently, let's say for example, she arrived at Seremban Hospital. She waited for about 24 hours, the whole day lah, unattended by the doctor. Subsequently, she bled to her death. Dia mati. Okay. So in this sort of case, if there is any gross negligence, probably the new act, the delay itself, would have contributed to the death. But in this issue, none of it. None of it, huh? Okay. And failure to mitigate loss is one thing. If you have noticed, As the plaintiff, we cannot take advantage of a civil case. Okay, it's not you get a top case, it's like you win a lottery. You can claim whatever you want uh, based on your receipts and bills, you have to mitigate the loss. So why I put mitigation of loss is that why did the plaintiff go to Colombia, Asia, which is expensive as compared to Seremban? But I think this is also very weak defense. Okay, the counter argument put forward by the plaintiff is that because I waited there, the public hospital do not have adequate staff to treat me promptly. Therefore, I need to rush to the private hospital to seek immediate medical attention. So this one also very weak punya defense lah. Okay, but this is roughly how you put up your answer for question A. And B is how far is the guilty plea relevant to the course of action? Okay. The guilty plea itself is negligence with respect to any animal. So this case itself is relevant. It's relevant because it is a form of confession. Any guilty plea does not actually does not prove the civil wrong of a defendant. Okay, because our criminal court and also the civil court are separate. Okay, they are two different proceeding. But somehow or other, the guilty plea by Madam Wong here is of high probative value. Why? Because it is a form of confession on part of Madam Wong to confess to the court that to admit that okay she herself negligence in taking care of the dog, causing danger to human. So this one is very relevant. Anyhow, if you look back the question carefully, the suit itself is of negligence, isn't it? And it has got four elements: duty of care, DOC, breach, causation, and damage. The guilty plea itself will help to reduce the burden of proof in duty of care part and also the breach of duty of care. Can you understand me? But somehow, as the plaintiff, you still need to bear the causation, but for and also how much damage you have suffered to win the whole case. You get me? So you only help to lighten the plaintiff legal burden in the sense of duty of care as well as standard of care. Breach of duty of care. Okay, causation and also damage you still need to prove. Okay, so this is how you argue. So I put in red now. Okay, this part you have to argue like that, and you can cite one case here. Ahmad Ikhwan, Ahmad Fauzi against Muhammad Fahimi Endut. Okay. So next question. Um, if you come to a cause, there is a cause of action available. You are asked to elaborate on each heading of the damages suffered. Okay, and also carefully assess how those damages are assessed by the court. You are also need to elaborate on the principle on how the assessment of such damages should occur. Okay, first thing first, in tort, there is one very important legal principle. Okay, that means to say This is called restitution. Okay, restitution means, let's say the plaintiff in this question were not beaten by the dog, that will be their original position that should be entitled. Okay, so the damage serve as the purpose to put the claimants or the plaintiff to her original position, as they had not been beaten by the dog at all. I give you one example. If Alam Yap would not bitten by by the dog at all, she would have working as a beautician without the need to take leave, without the need to suffer from an ugly permanent scar, isn't it? So this is how the court will look at it, to restore to original position. Okay. And the so-called the court in Malaysia, we only have a few types of damages lah. In tort, we have a few types: general damages and also special damages. Damages is with the S, okay, it's money, please, money, and there is another form of damages we call aggravated damages in tort. This one is quite popular to be pleaded in negligence case. Okay, with special damages means any damages pecuniary in nature, monetary loss, that you could prove with receipt before the trial. Okay, normally we refer it to pre pre-trial or out of pocket expenses. Okay, special damages. Whereas that general damages are those which include pain and suffering, loss of amenities, loss of future earning, loss of earning capacity, etc. So these are the damages to be evaluated by the court. You do not need to produce exact receipt. Okay, but somehow or other, even having said so, you still need to prove those claims really exist. For example, if you say in this question, the kid, isn't it, suffer from acute stress disorder, isn't it? This is one of the general damages pointing to what? To what? To the heading of pain and suffering, correct? Because the child probably having some trauma after this horrible incident. You need to produce proof to prove this pain and suffering. How you want to how you want to prove is that you tender a medical report, okay, to prove this claim really exists. Okay, so this is how I okay. Another species that I forgot to put inside, but I did put somewhere here, is aggravated damage. Aggravated damages is a species of damages that the court normally will not grant, except for the mischief behavior on part of the defendant. If let's say this defendant appears to be in denial, do not want to admit liability, file a lot of interlocutory application in the court, purposely delay the whole proceeding, okay, or when asked to give what we call the true account of the CCTV footage, refuse to give, all these of sort of negative behaviors will actually trigger the court to give aggravated damage, because you are giving secondary trauma to the plaintiff. By right, let's say if this case is a clear, straightforward, isn't it? The dog bites plaintiff injured. But CCTV you don't want to give. Then later on you challenge, I do not own the dog. the ownership is dispute. Or you purposely want to make the whole thing so difficult, so many witnesses are being called, you habis lah. Okay, the court will impose aggravated damage because they think special and general damages are not sufficient to compensate the loss suffered by the plaintiff due to the behavior of the defendant. Okay, so this is aggravated damage. So this is very often being pleaded. And to refer to damage suffered, you have to refer to one guidelines, the revised compendium of personal injury awards. Okay, this one is persuasive. Okay, this is actually the bar council is the one that proposed it so that each and everyone could get certainty when we are getting the award. Okay, take for example, if you lost one finger, amputation, your index finger got amputation, or we are looking at the amount of 10,000 ringgit. So Dr. Chi will tell 10,000 ringgit. And the other lawyer, Mr. Lee, probably will tell also 10,000 ringgit. Not like there's a lot of differences, you know. One lawyer will tell, oh, you can get 1 million for sure, like that. So where's the guideline? So this is one guideline that I think you should put lah. Okay. So special damages, after you have discussed a little bit of the legal principle, what you should do is you should identify what are the out of pocket expenses that the plaintiff have suffered so far. Okay, so in a very short manner, you can say that the plaintiff are entitled to recover every ringgit they can prove they have actually spent or lost as a direct consequence of the dog attack. Okay, and the medical bills, of course, they are entitled to claim. Okay, but medical bills one, there is one so-called the triable issue. Like we have previously said, why you switch from a government hospital that incur minimal cost to Columbia Asia. Okay, so you must argue here lah. Okay, you use the case of Chai Yi Chong against Yu Tai. Okay, so Chai Yi Chong and Yu Tai said that no doubt, the plaintiff need to mitigate the loss, but insofar as it satisfies the test of reasonableness, okay, as long as the plaintiff can justify the reason why they need to transfer to private hospital in this particular case is because of the delay in Seremban General, isn't it? So Mrs. Alam and also Chinmay as the plaintiff can claim in full. Okay. One more thing, one third principal rule no, already no more, you know. Okay, already no more. The court will not shed this sort of liability across. That means to say, okay lah, deduct one third lah because you want to choose private, you want to enjoy single room, isn't it? So I give you discount one third. Take for example, 30,000 Columbia Asia bill, I only award you 20,000. Not like that. The court will award in full so long the reasons given by the plaintiff are acceptable. Okay. And Mrs. Alam in particular have suffered from some residual weakness and also she need to do dressing, physiotherapy, isn't it? So all these bills could be claimed. Okay. She also earned, isn't it? She earned about 8,000 ringgit per month. Okay, so this one also you must put lah. Don't put a very general and vague answer. Please particularize your claim. As in you read the question already, you are now telling the clients what to claim. Okay, so tell them 8,000 you earn, you can whatever leave that you have taken. Okay, because the medical report suggests that she may need up to 1 year punya physiotherapy, isn't it? So probably that 1 year you can claim in full. Okay. But the facts does not suggest so lah. Okay. I will put my drafting in such a way is that the court will probably award the full net figure loss from the day of incident until the moment she start to work. Okay, so this is how. And you must remember, this is a 2024 paper. It has been 2 years, since the incident. They only filed the suit a bit late. Okay. And finally, any miscellaneous expenditure, for example, uh, emergency child care when Mrs. Alam was hospitalized, because you remember she underwent one emergency surgery. So how about Cime? Tak ada orang jaga. So if you hire anyone to take care, you can claim. Okay. For example, you lose property, isn't it? Loss of property, blood-stained clothes, logistic through and fro the hospital, the fees to obtain medical and police report. All this I did not fake because they give you police report and also medical reports, isn't it? You need to pay to the hospital one, 100 over ringgit to get one piece of medical reports. Okay. So this one you also can claim so long you can furnish the court with the concrete proof of payment. Okay, in terms of general damages, pain, suffering, loss of amenities, you can put under one limb or second, two limbs also, never mind. Okay. Um, Again, okay, when the court award, it will evaluate lah what kind of injury that you really suffered in resulting this sort of pain. You don't describe to the examiners say that, oh yeah lah, you have suffered pain and suffering due to this dog bitten. But what injuries that warrant the amount of pain and suffering leh? Okay, so you must look at the nature and severity of the wound. So where you can find medical report appendix C. Betul tak? You substantiate your answer not by hearsay, by documentary evidence as provided by the examiners. Okay, so you notice that this is not superficial wound, isn't it? The wound is quite serious. It's a deep puncture wound, isn't it? Up to the fascia and also the muscle. One layer down will reach the bone. Okay, so all this coming from medical report appendix C, okay, which suggests that the wound of serious in nature, okay, and highly devastating to the plaintiff. Okay, and then treatment required. Emergency open surgery. It's not just put some ointment and then ask her to go back, isn't it? It needs exploratory surgery, wound debridement, dressing, IV antibiotic, etc. So it means to say the thing is not just simple lah, okay, and impact on occupational and daily life. So continuous headache, okay, vertigo, migraine lah, and then reduce in the dexterity of the limb, the fine motor. Now want to wash the face of the customer also a bit kekok. Okay, all this will justify the court to award more pain and suffering. Okay, on part of Mrs. Alam. Okay, be a bit professional in your answer. Okay, whereas for Chin Mei, you can also get the information that you need from medical report, appendix D, Dr. Prisha's medical report. Okay, first thing first, she did suffer from some laceration, but I think this is a minor one lah. But somehow, as being a child who is only 6 years old at that material time, she had acute stress disorder. Okay, acute stress disorder. So this is a psychiatry injury. Therefore, apart from physical injury, this kid also had emotional breakdown due to the dog biting incident. So she will probably need counseling and other psychological report as postulated inside this report. So this one you can put forward to sustain your claim. As in loss of future earning and also loss of earning capacity, huh? My personal opinion is that you can only claim up to the point of 1 year lah, or whenever you are out of work, because this form of injury, reading on the surface itself, is not a permanent disability. Correct? It's not like after the dog biting incident, Mrs. Alam had been bedridden, isn't it? So she still can work. Okay. So I will say that, but now I have one issue lah, because the date of incident is 2022, isn't it? 27 April. But now the date of filing is what? 2024, 11, 11. So it's already 2 years, you know. The medical report only suggested 1 year follow-up and physiotherapy. So I actually a bit stuck, to be honest. I quite stuck here. But I put a little bit sensible one lah to avoid the so-called repercussion. I said that you can claim 8,000 ringgit multiply by the number of full months from 27 April 2022 to the date of judgment, provided Mrs. Alam remain out of work for medically justifiable reason. Okay? Then you quickly tell the examiner, say that, oh, sir, I read this report actually. So Appendix C indicates that she will only require further assessment physiotherapy for at least a year, but it does not suggest any permanent disability. Therefore, Section 28A, Subrule 2, Subrule D, Subrule Roman 2, Civil Law Act, the multipliers multiplicans rule has no room of application. Okay? uh, let's say, let's say for example, okay, let's say for example, I also consider her job as a beautician. She had permanent scarring, isn't it? And also the reduced dexterity, the fine motor function of the hands probably affected. The fingers are not longer moving smoothly. Okay, what normally will do is that if let's say, for example, if you can find a job other than a beautician, let's say if beautician, you cannot work anymore, isn't it? You claim that you have lost that ability because you are ugly now and all. Okay, now you switch to become a sales representative, but now you earn less. You earn about 5,000 per month. So the differences between the salary, so long you can prove, you can claim. So this is what this sentence meant, okay? You get what I'm saying, So long it reflects the reality, you are entitled to claim. No doubt we are saying that there's no permanent disability, but let's say, for example, she can't work as a beautician, her claim is still valid, okay? Hmm. And by all means, this is very important. The plaintiff will still need to take reasonable step to mitigate a loss. She cannot take a very long holiday without any medical certificate. Like she enjoy lah, she go to Paris, she go to Tokyo, but then at the end of the day, she can work. She want to take advantage of this claim, cannot. Okay. So scarring, disfigurement is the one that I'm talking about. Okay, I think they said it. The figure, not separate the figure lah. A figure, fosse. Okay, and aggravated damages is like what I said lah. If let's say, for example, the the defendant's behavior is really bad, very bad, and then she did a lot of inappropriate things that probably will annoy the judge. The judge will give aggravated damages to the plaintiff in order to teach the defendant a lesson. Okay. And as far as it goes, you must also try to claim interest. Okay. Interest also quite important. Normally, it is calculated from the date of the incident, um, pre-trial judgment interest. Pre-judgment interest, and also you have another thing called post-judgment interest. That is from the date the judgment is being pronounced by the court until the realization of that judgment sum. So you have two things lah. Okay, interest. And what about collateral benefits? For example, if the Columbia Asia bill is well covered by medical insurance, the court already recognized, say that any gratuity, pension, or whatever gift that you have accepted or insurance that you have accepted for the personal injury claim, you can still entitle to second time. You can claim the same amount from the defendant. Okay, take for example, initially I told you the general principle is to put the plaintiff into the original position, isn't it? Okay, position. Now we have a scenario. The medical bill of Columbia Asia is 30,000 ringgit. But this one is not paid by the plaintiff. It's paid by the insurance company. The problems for you is that is plaintiff entitled to get this amount of money since she does not spend it, correct or not? If she get it, it will result in unjust enrichment. Okay, which means dia dapat sesuatu manfaat yang tidak adil, because at the end of the day she get double pay lah. Insurance pay her, and then defendant also pay her. But in case of this one, Su Chengling against Somewhere Medical Center, it is tried law already. It is undisputable, as per Malaysia court per se. Any form, because this is the statutory wording, okay, section 28A sub rule 1 and ABC. Okay, any form of insurance claim you are able to claim from the defendant in full. Okay, no deduction. Okay, so this is what I want to emphasize. Okay, so before I go to apa nama a statement of claim, which I think you really need to draft nicely here, is there any questions so far? There's one. If the answer is written like that, i.e., escape, attack, etc., is it short form? If you read my context as a whole, I think I just want to explain the chain of incident lah. Okay, it is not meant for you to write everything short in the examination. You have to write in full. But here, what I'm trying to say is that There's an unbroken causal link. Causal link is the most tricky part of the negligence law, you know. You don't think but for is easily applicable, eh? Sometimes a lot of people actually, you see, the duty of care very hard because case law are there to support that the relationship do owe duty of care. Breach also not too hard as long as there is some faults of the defendants you can prove. But the causation is tricky part, and most of the lawyers will play very hard to challenge. You see, the causation is broken, so nothing concern my client. Okay, so this is what I want to tell you here lah. Okay, apa lagi eh? If you are common situation, no, normally they won't ask you some novel situation lah. They'll ask you accident cases mostly. So I don't think not Donahue and Stevenson will be sufficient to discuss about the so-called the duty of care issue. Mm. Okay, so last but not least, we go to statement of claim. Okay, statement of claim, by looking at the damages that we have discussed, isn't it? I think it will fall under the jurisdiction of session court because the amount of claim will be less than 1 million. Okay, correct, huh? And the place where the court should listen to this trial is that it will be at Seremban. Okay, the format must be written in a correct manner and in this capital form. Jangan tulis huruf kecil, tolong, salah ni. Okay, so write in capital letter, civil suit number, leave it blank. Then second, you have between, this one do miss out. And first, do a numerical numbering here because you have two plaintiffs. Is an S here. Okay, one is Alam Yap. Okay, Alam Yap, followed by NRIC. If you don't have, also is okay. Sometimes it's okay. And you say this is first plaintiff, easier. And second, Chinmay. Okay, Chinmay, you must put like this. A minor suing by her next friend and mother, Alam Yap, because she is minor. A minor is a person under disability. She has no legal capacity to sue. She must sue through an adult, a guardian. Okay, faham So this is the second plaintiff. And the only plaintiff we have is Madam Wong, but we do know her full name. So it's okay for us to leave it blank, Madam Wong, like that. No choice, because no information to make up. Okay. And you write here, statement of claim. The first few paragraph, the first three paragraph, you will need to introduce um, the the parties sufficiently. Okay, so how you draft is the first plaintiff is a Malaysian individual, ordinarily reside lah. There's a typo. Okay, ordinarily reside at number XXX, okay, Jalan Wat, Setia Heights, okay, Seremban Negeri Sembilan. And all material time, the plaintiff works as a beautician. So this one you plead already, the job and the job of the first plaintiff. Okay, the second plaintiff is who? Is a Malaysian individual who is a minor with residential address, same with the first plaintiff because they probably will stay at the same house, isn't it? Okay, so you have to introduce the second plaintiff is the daughter of the first plaintiff, and at all material time, second plaintiff sue by her next friend and mother, the first plaintiff. Okay, as simple as that. Whereas the defendant is who? The defendant is also a Malaysian individual. Okay, this one you can get the address from police report, It says nombor 1338 Setia Heights. Okay, so this one I suppose anyone who finished the exam will buy 4D lah, the Toto for this number. I don't know whether they got it or not. Okay, so 1338. Okay, and all material time. Who is the defendant? The defendant is actually not being sued for her own fault. She is what? She is the owner and person in control of the Rottweiler dog kept at her residence. So this is how. And you have one discrepancy issues that I've told you earlier. What is the time of the incident? Okay. The story said 6 p.m., but the police report as well as the Seremban medical report suggest 7:25. Follow the documentary evidence. Okay, so I would say 7:25, 27 April 2022, the plaintiff were descending the public footpath adjacent to the defendant's premise after a routine hike. Okay, see, so this is the how the incident happened. Without warning, the defendant's Rottweiler escaped through the defendant's front gate, measure only 4 feet in height. All this is material facts, and unsecure and viciously attacked the second plaintiff. So what happened next? Because the kid got attacked first, isn't it? Then the plaintiff attempt to fend off the what we call the dog. Okay, and actually shield lah, not with this one. Okay, and shield the second plaintiff with her body. Thereafter, the dog beat the first plaintiff repeatedly and knocked her to the ground. Okay. After that, the first plaintiff, definitely because she suffered from pain, she cried for help. A few neighbors respond to the cries for help. Subsequently, defendant emerged also, appear and witness the whole incident. Okay, you can realize I do not actually plead she pulled off the dog, isn't it? The dog away. Any reason for me not to do so? Because it will help her, in her case. What will really assist us in this case is that she's here, she witnessed it, she cannot deny. That's it. This one, if it is not so favorable, I think you don't have to put. I think you don't have to put. Okay. Because it will be their defense, mitigate loss. Okay. See, if I do not come out, the dog will beat you, maybe to death. Something like that. Okay. So both plaintiffs were injured by the dog after the incident. They were rushed to the Seremban General Hospital, SGH, approximately on the same day. So due to the delayed treatment, you see, it justified already. The first plaintiff later transferred at her own cost to Columbia Asia Hospital. But the medical records will say transfer at her own risk, isn't it? Don't use something that is so unfavorable to you. When you drive, just be a bit smart and professional. Okay? Don't say at own risk lah. That means to say you don't follow the doctor advice, is it? Cannot. So you have to say transfer at her own cost to Columbia Asia, and where she underwent emergency hospital and on 28 April and subsequently hospitalized until 3rd of May 2022. So following the dog bites, both plaintiffs sustained physical and psychological injuries. Then you plead slowly. Particulars of first plaintiff injury. This one all copy and cut from medical reports. Okay, the remaining this one is actually from the story, so you have to read carefully. So this one is actually also inside the medical report in the last paragraph. Okay, you just make sure it is there. Okay. And then subsequently, because inside our the answer 2C, we have pleaded the plaintiff, the first plaintiff might cease to work as a beautician, isn't it? So you must say the permanent scarring, see, the permanent scarring reduce dexterity and also the pain at the wound site. Okay, these cause her stop working as a beautician until full recovery is achieved. Okay, so whenever you draft your story, make sure if let's say for example you are first time reader, roughly you can get about 50-60% of the whole story, isn't it? Then when you look at it like that, then your statement of claim is sound. You get me? If you do know what you are writing, and you ask your friend to read also, hey, I don't get what is it, lah. Do you think it will be it will be an impressive version of statement of claim, then you want the examiners to give you mark? Statement of claim, like I say, is a pleading. If you get it wrong, you don't get your perbicaraan. Tak ada. Because it is bound by the four corners of the pleading. That's why statement of claim, statement of defense, very important. Okay. And particulars of second plaintiff injuries include laceration wound over left elbow. That one also you can just apa nama, copy and paste from medical report. So long you read it lah. Acute stress disorder, okay, and require the psychological follow-up. Okay, so the injuries suffered by the plaintiff were wholly or partly due to the negligence of the defendants as the owner and person in control of Rottweiler dog. Again, you go and tell to the court, to the readers that read this statement of claim, that you see defendant is actually the owner, repeatedly said. Okay, so the defendant's negligence is what? You particularize, permitting the Rottweiler, okay, without physical restraint, number one. Okay, the the gate itself is not properly shut or latched or locked. Okay, that's why the dog pushed, the gate can open. Okay, so perimeter of the gate also not at the sufficient height, isn't it? Okay, then fail to put the dog in a cage. Okay, fail to display a warning signage to the plaintiff. So fail to put the dog muzzle. Okay, otherwise fail to train, socialize the Rottweiler so can get along with human lah. Why your dog is so particularly vicious and fierce? Okay, and fail to, when the dog escape, immediately restrain it and to prevent it, okay, from harming the plaintiff, okay, or harm the plaintiff. Okay, so apart from the said particular of negligence, apart from it, you also need to plead, the license, because it is given from the facts. That's why they give you 20 marks. There's a reason, a lot of things as compared to your contract question to be pleaded here. Dia tak ada license. Okay, no doubt I say this might not be a good point to say that it could be a form of negligence, but still it could mean the lack of control of this defendant as the owner of the dog. Okay. And also plead guilty one. Plead guilty, you must specifically plead. If you do not plead this fact, you cannot rely in the court later on. So you must plead the defendant was charged to section 298 and defendant was fined. Plead guilty and fined. Okay. Apart from the foregoing, the plaintiff have incurred also out of pocket expenses as a direct result of the defendant's negligence. So you list down the particular. So Seremban General Hospital berapa? Columbia Asia, how much? So physiotherapy, how much? All these you put out as particulars for special damages, and then you put a sum. And lastly, you pray that the plaintiffs claim special damages in the sum of XYZ, general damages, aggravated damages, don't forget, interest, cost, such further and other relief as this honorable court deemed fit and proper to grant. And date, I already told you last time, put the date of examination and sign this. You must sign this statement of claim, and solicitors for plaintiff and the what we call the footnote also is like that. This is according to standard format. Okay, you must put your firm's name. Okay, the one, for example, ABC, the solicitors for plaintiff. I normally encourage you all to put your address lah, because you all write your address multiple times already, isn't it? In whatever form that you have filled to the bank, whatever. So it comes into a reflex, you know. You don't have to think of the new address. You just put your own and put in the telephone number. Okay, as simple as that. But statement of claim, I think requires a lot of practice, lah, isn't it? Otherwise, you draft a haywire and the story itself, lah, is not beautiful enough to appreciate, you know. Hmm. And we can see one, you know, actually. I mean, of course, I've been practicing for, uh, up to 2 years plus now. So when I read back my first drafted statement of claim, I feel I'm so childish. Seriously. So, uh, when those people with 20 years standing, they are marking your statement of claim, so they'll look tediously for whatever factual information you can provide to them, not a general one. Okay? Wait, I'm looking.